All right, so we're going to get started here in just a moment. I'm going to invite Chris, our lawyer here, in just a sec. And while I work on his video, we'll have his audio, no problem there. And if he wants to click on the, he has capability of clicking on the audio, that would be great. Thank you, Chris. I think this has just joined us here. I'm going to go ahead and start, and I'll tell the participants behind me that we're starting here. We have about 30 participants here at the Coffee Roastery behind me, and we're all here to learn about the just newly passed ordinances in Fairfax. I'm Mike Sexton. I'm one of the organizers of fairfaxresidents.org. Fairfaxresidents.org is a group of residents who are concerned with housing in Fairfax and how rent control ordinances affect renters, landlords, and homeowners. We're here at the Coffee Roastery, joined with about 123 attendants, along with about 30 people at the Coffee Roastery. We're concerned citizens, and we're concerned about how these new ordinances, referred to as just cause and rent stabilization, were passed by only the town council in November. Residents here and online want to understand why they were not allowed to vote on these measures, even though the ordinances have such consequences for their current income, their retirement, and the control of their property. We might not be able to answer that question, why we weren't able to vote on it, but the answer lies with the town council. But we can bring in speakers and give an overview about these ordinances, address some of the legal implications and liabilities and burdens brought on to the mom and pop landlords, and how these ordinances may actually cause rents to rise by reducing rental supply. Later in this program, I'll bring on Blaine Morris, a local realtor with over 20 years experience with the real estate transactions in Fairfax and surrounding communities. But for now, I'd like to welcome Chris Skinnell, an attorney who has litigated a number of constitutional issues related to property rights, the use of public funds in connection with ballot measure campaigns, and the legality of various electoral systems. Chris, we'll start off with you and an overview of the two ordinances, what they do beyond what's in California already in place, and what are some of the legal implications for homeowners and landlords. So Chris, are you with us here?
I am, Michael, thank you. I'm going to try, okay. I was going to try and share a PowerPoint, but it looks like that's disabled too. So I'm just going to jump into the substance, and if we can share it at some point, so be it. If not, not. But we'll cover a fair amount of ground. These rules are very complex. They're about 40 pages of text combined. So there's a lot of twists and turns. We're going to pitch this at sort of a high-ish level. We can't cover every single detail, every single twist and turn, but we're going to cover a fair amount. But I do want to start with sort of the general caveat that lawyers always start with in this situation. These are meant to be for general informational purposes. They are not meant to be legal advice. So anybody who is dealing with a specific circumstance and has questions about how these rules apply to their specific case, you really need to consult a lawyer. But with that caveat, the idea is to give a broad overview. What are these two rules? What do they do? How do they affect property owners? And what I'm going to cover is sort of the inner working or interaction of several different laws. To begin with, the just cause and rent mediation ordinances that the town council adopted in 2019. Fairfax already has versions of these laws in place and has for several years. Now, the new ones are much more burdensome, much more complicated. We're going to kind of talk through a comparison of how they relate to one another. We're also going to discuss, as part of the mix, the relevant state laws that come into play. So the Costa-Hawkins-Revel Housing Act, which sets rules about which units can be subject to rent control, how that all works. The State Ellis Act, which governs the ability to take a rental unit off the market. And Assembly Bill 1482, which the legislature adopted in 2019, and which adopts statewide versions of both just cause and rent control, but does so in a much more general way, not nearly as restrictive as these new rules. And so The focus primarily, though, of course, is going to be the two rules that were adopted, the ordinances on November 2nd, 2022, took effect in December, Ordinance 870 and 871. As I said, they took effect in December. One sort of twist on that is that the town council, in adopting the ordinances, provided that they won't begin implementing the rules until such time as sufficient agreements for implementation, support, including but not limited to staffing and hearings and all that stuff, have been approved by the town council. So, that creates a sort of a weird situation because some provisions of the ordinances seem to be in effect now, and some are not really going to be able to be in effect or implemented until a future time that the town council takes further action to approve the implementation by city staff. So with that, I'm going to start off even with the just cause for eviction rules because they apply a little bit more broadly to more units than the rules that apply, the rent control rules have fewer exemptions. I thought I'd start off with, who's covered and who's not. Obviously important first question. Under Fairfax's 2019 ordinance, pretty much all of the rental, residential units within the city, including single rooms, et cetera, are covered by the existing just cause for eviction law. There are exemptions for units owned or operated by a government agency, for units where the government subsidizes the rent to keep it under 30% of household income. So I think, Section 8 type things. There is an exemption for units where at least half the units are affordable as defined by state law. Junior accessory dwelling units are exempt. Units owned by a tenant who manages the property, so property manager who lives on the property, and rooms where in a single family home where the landlord also lives there. Fairfax's the 2022 ordinance tightens those limits and applies just cause for eviction to even more units than already were covered under 2019. Again, it's most units, including individual rooms within a home that are rented out. The exemption for government agencies only applies now if it's owned, operated, and managed by a government agency, and if state or federal law exempts the unit from rent control. Now, why exempt from rent control? It seems like maybe sort of a holdover from the other, the rent control ordinance. Oh, there we go. But for whatever reason, they've incorporated that into the just cause eviction as well. Here we go. Hopefully you can see that. The affordable housing exemption is now restricted to developments where 100% of the units are exempt as opposed to only half. There is an exemption for hotels and motels, but it appears on the face of it that, for example, short-term rentals are covered by these rules. Airbnb, VRBO, that sort of thing. And then there is an exemption for sort of group quarters, so to speak, hospitals, convents, monasteries, medical care facilities, et cetera. And sort of the one important takeaway here is that anybody who's relying on these exemptions needs to include them and refer to them specifically in a notice of eviction or in the eviction lawsuit, the unlawful detainer action. So if you don't do that, then that's a defense to the eviction proceedings. Under state law, basically any unit that's covered by a local ordinance like Fairfax's is exempt. And so as a functional matter, with respect to this particular issue, Assembly Bill 1482 doesn't really apply because the Fairfax ordinance is more restrictive than AB 1482. So there are units that wouldn't necessarily be covered under state law, but are covered under the 2002 ordinance, including new construction units, single family homes, that sort of thing. So, kind of talk about in broad brush what constitutes just cause. The rule is essentially that you cannot evict a tenant from your unit unless you can identify one of the particular specified reasons that are laid out in the ordinance. And what the just cause rules. And there are really two categories of just cause rules. There are the ones at the top of this list here that are not in bold, which you would call sort of for fault or good cause reasons. And then you have the ones at the bottom that are not fault. They're not because the tenant has necessarily done anything wrong, but because of the circumstances of the landlord. And so, in a lot of respects, all of these ordinances cover the same basic concepts, but there are some distinctions worth flagging that we'll talk about in some detail here, particularly with respect to the for cause reasons. What constitutes a legitimate for cause reason based on something that the tenant has done. So we'll start there. The most common, obviously, is failure to pay rent. The 2019 ordinance basically just follows state law, as if the ordinance didn't exist at all. The normal rules, they don't pay rent, you give a 3-day notice to evict, and you then go and pursue an unlawful detainer. The 2002 ordinance basically does the same, but with a couple of caveats. Now there is the possible defense that the landlord basically refused to accept rent from the tenant or made it difficult for a third party to pay. So, some sort of like nonprofit assistance, that sort of thing. And of course, this is subject to the rent control rules that we're going to talk about further on. The second big category that comes up, very commonly is the breach of a material lease term. And again, the 2019 ordinance just basically followed state law. If someone breached a lease term, you had to give notice, give an opportunity to cure it, and then you could, if they continued to do it, you could go ahead and evict on that basis. The 2022 ordinance does the same thing, but again with a couple of additional caveats. The term in particular has to be now accepted in writing by the tenant. And if it wasn't in the original lease, you have to include notice in the updated lease that specifically tells them that they don't have to accept the new term. And then there's also sort of an exception if they can establish that it's not a reasonable term, that's a defense to the breach. Although that is to some extent true also of state law anyway. The big exception, though, that the new ordinance adopts with respect to the breach of material lease relates to the number of people living in the unit. Under state law, if you can set a cap on how many people can live in the unit, and you can restrict subletting. The 2002 ordinance really limits your ability to enforce those terms. Now, if a tenant requests the ability to add new tenants or to sublet to anybody, you have to reasonably agree to that, provided that the original tenant continues to live there, or that they are replacing tenants who are leaving. So one person moves out and the remaining tenants bring somebody new in, and with the caveat that they can only do it up to the number of people that are the maximum permitted by state building codes, obviously for health and safety reasons. And so the way it works is the tenant sends a request to the landlord, can I either add new tenants or can I sublet? You have 14 days to respond. If you don't respond, you're assumed to have granted permission. If you do respond and you deny it, it has to be based on a legitimate reason. You have to tell them what that is. And the subtenant's lack of creditworthiness is not a good reason, unless they're going to pay the rent directly to the landlord. If the legal responsibility rests on the original tenants and they're just collecting rent from the subtenant, then their poor credit is not a reason for you to refuse to allow them to move in. Before you evict based on the presence of more people than are permitted under the lease, you have to give them the opportunity to cure, and they can do that by asking for permission, subject to the rules about 14 days, etc. And beyond that, there are also limits on your ability to refuse additional tenants who are either the spouse or the domestic partner of the original tenant, a child, parent, grandchild, grandparent, brother, sister of the original tenant, or any of those relatives, spouses. So this isn't even the 14-day rule. This is you just can't refuse so long as they, again, don't exceed the maximum number allowed under the state building codes. Some additional bases for cause. Under the 2019 ordinance, there were specific grounds for evicting based on the illegal activities of a tenant. So if you were doing things like, drug dealing or, gun possession or anything like that, that during the period of the tenancy and either within the unit or within 1,000 feet of the unit, that would be a basis for eviction. The new ordinance does not include a specific exception for that. It may, those sorts of illegal activities may be covered under rules related to nuisance and damage, but there's no express exception specifically for just illegal activities in general. And the fact that someone was arrested or convicted of a crime is not per se evidence of any sort of nuisance that would allow you to evict. It's also more limited to just the unit itself. Nuisance and damage, unlike the prior rules, really is now just limited to any sort of damage or nuisance in the rental unit itself, as opposed to on the property more generally. And the same goes for any sort of damage or waste. It used to be under the 2019 rule that if the tenant was damaging either the property of the landlord or the property of other tenants, they could be evicted. Now it's really, again, just limited to damage to the rental unit that they are in possession of. Few other notes about this sort of these for cause, the good reasons based on tenant activities. Under the 2019 ordinance, unlike the 2019 ordinance, the 2002 ordinance, 22 ordinance has an express provision allowing you to evict if the tenant refuses to give you reasonable access to the unit for repairs or to show for a potential purchaser or mortgager. That was not actually in the 2019 ordinance. It's kind of probably implicit, but it didn't specifically spell it out. Beyond that, state law generally, the normal just cause rules that apply under AB 1482, allow a landlord, specifically when a lease term ends, to insist that the tenant sign a new lease and not go month to month. So, ask them to sign a 1-year lease to extend it. And if they refuse, then that's a basis for eviction. Under the Fairfax ordinance, that is not the case. The landlord has to allow the tenant to go up to a month-to-month tenancy at that point. Also, unlike state law, you can't kick somebody out if they give you notice and say, I'm moving out, and then change their mind and don't do it. That's specifically in the AB 1482 system, but it is not an exception that's built into the Fairfax ordinances. And this may not come up very often, but I thought I'd mention it. If the person is a tenant because they are an employee of the landlord, again, this kind of goes maybe back to the property manager example, and they suddenly are no longer an employee or an agent of the landlord, under state law, that would be a basis for evicting. Under the Fairfax ordinances, that's not true. So again, it may not come up all that often, but one additional restriction compared to state law. That said, obviously these are more restrictive than the 2019 ordinance. They're more restrictive than state law. But where the real action is primarily is with respect to the no-fault evictions. This is where things get much, much more complicated and much, much more restrictive than was previously the case. Just a first sort of note. Under the 2019 ordinance, there was a specific provision saying, look, nothing in this ordinance is meant to prevent you from agreeing with the tenant that they'll move out. We'll forgive 1 month rent if you move out and don't give me a hassle. I don't have to file a lawsuit. That is still the case under the 2022 ordinance, but with some new restrictions and some new requirements. Now, any type of a buyout agreement like that has to be in writing. It can't be oral. It has to be provided to the tenant in English, and if they ask for it to be translated into another language, it has to be provided in that other language too. It has to include statements telling them that they don't have to sign it, that they can talk to a lawyer before they sign it, and it has to. It includes a note for them to notice when the landlord provided the copy of the agreement, and you have to have that signed. And without those additional details, the buyout ordinance may not be enforceable in a UD action. An additional area of restriction, historically, it's always been possible to evict someone if there's something wrong with the unit and you need to get them out so that you can do repairs. Under the 2019 ordinance, it specifically provided that opportunity. They had to be significant repairs. They had to be such that they were necessary to bring the unit into compliance with health and safety codes. They couldn't be cosmetic or superficial. They had to be significant health or safety issues. But in that circumstance, you could evict the tenant, and there was no requirement to pay any sort of costs, or there were no limits beyond that. This is much more restricted now under the 2022 ordinance. First of all, it's not an eviction in the strictest sense anymore. Now the removal is temporary for the tenant. And if it's less than 30 days and the repairs can be completed in less than 30 days, the way it works is you provide short-term rental payments at a daily rate. And so they have rates specified in the ordinance for hotel, for food, for various other costs related to being displaced, including pets. And you provide the amount that you expect to need to pay at the time you provide the notice to remove them. If you tell them, hey, it's going to be 2 weeks, you provide the notice, give them the fees for 2 weeks, and then hey, it turns out it's really going to take 3 weeks, then you need to continue to pay at that daily rate, and you make the payments on a weekly basis for each new week. If the tenant accepts those short-term payments, then they have to continue to pay rent, but they have the option of refusing the sort of costs. And in that case, they are exempt from rent until they return to the unit. And those numbers, those rates, the daily rates, the cost for hotels, et cetera, they're subject to an annual increase based on CPI costs. If you anticipate that the repairs are going to take more than 30 days, it's different. In that circumstance, you remove them from the unit completely. If you have another unit within the town that has the same number of bedrooms or fewer and that's vacant, then you have to offer them that alternative unit. And either at the cost that they're already paying, or if the other unit is actually subject to a lower rate for some reason, at the lower rate. So whichever one is less. And you have to offer them a term that's 90 days or until the repairs are complete, whichever is shorter. And in addition, unlike under the 2019 ordinance, you have to pay relocation costs, significant relocation costs. It amounts to 2 months rent. Plus, if any of the tenants are either 62 or over, or 18 or under, so basically minors, they're disabled or terminally ill, then you have to pay an additional $3,000 in relocation costs. And then once you've completed the repairs, you have to give the tenant the opportunity to move back into the repaired unit. They have 60 days to take advantage of that opportunity. Next ground for eviction, besides repairs, is so-called owner move-in. So you own a unit and you've rented it out, and you decide, hey, I want to move into that unit myself, or I want to move a family member into the unit. You can do that, but it's again subject to restrictions and much more stringent under the new ordinance than it was under the old. Under the 2019 ordinance, it could be any one of a number of family members, including the landlord's parents, grandparents, brothers, sisters, aunts, uncles, nieces, nephews, kids, so long as they were going to move in and use that unit for their primary residence. And you basically had, after you evicted, you had 3 months to take over the unit. And you had to do it with the intention of living there for at least a year to take advantage of that exception. There was no specific remedy built in, but if you didn't do it, then a tenant could theoretically go and get an injunction. But again, there was no requirement to provide any sort of relocation payments or costs to take advantage of this rule under the 2019 ordinance. Under the new rule, there's a lot more restrictions. First of all, you have to act with good faith intent, and the lack of good faith is a defense that the tenant can raise potentially. They've limited the number of people you can move in. You can still do spouse, you can still do child, parent, or grandparent, but your brother, your sister, your nieces, your nephews, they're not allowed to take advantage of this exception anymore. To take advantage, the landlord has to be a natural person, so not corporate ownership of any sort, and they have to have at least a 51% ownership interest in the property. So it can't be sort of a fractional or a partial owner. Some additional restrictions: you can't move into a unit if using this exception if either you already live on the property or at least the would-be tenant. So even if it's a parent, grandparent, etc. If you already live in a rental unit on the property, you can't do it. Or if there's another vacant unit, you can't kick a tenant out and take their unit if there's already a vacant one there. And once you have picked a unit to kick somebody out based on this exception, that's the only one that can ever be used for that purpose. And you may be able to do it multiple times in the future, depending on circumstances, but you can't do it to a different unit down the line. With the caveat that if that unit is necessary for a disabled family member, and it's the only one that you can use for that purpose, then you can get an exception and apply for an exception. You still, again, have to intend to occupy the unit within 90 days, just as was the case before, but now there's some teeth to it. If you don't do that, you have to offer to let the tenant move back in again. And you have to pay reasonable moving expenses, both to and from the unit to the tenant. And it's your burden to show that it wasn't a bad faith notice that you sent out in the process. If the tenant says, you've offered to let them move back in and they say no, if they say yes, then it's at the old rent that they had before they left. If they don't take it, or say you do it 90 days down the line, a year down the line, you take it over, you actually live there for a year, but you re-rent it, then it again is at the old rent that the tenant had before, plus any adjustments that are allowable under the rent control ordinance in the meantime. So it's still limited. It's the rent is still restricted if you exercise this option and then you decide to re-rent it again in the future. Few additional limitations. You can't evict a tenant under this provision if there's another unit on the property and the occupant of that other unit hasn't been there as long. So it's kind of a first, last in, last out sort of situation. There are also restrictions for evicting either elderly or disabled tenants. So if they've lived there for at least 3 years and they're either 60 plus or disabled or terminally ill, then you can't remove them unless you have a family member who is also in that circumstance and needs the unit. Then you could do it. And then finally, if any of the residents is either an educator or a student and they've been there at least 12 months, you can't evict them during the school year. So only during the 3 months of the summer, essentially. A few additional items to note with respect to this exception. If you remove a tenant and then they eventually reoccupy, you cannot evict them for another 4 years. Additionally, as with the substantial rehabilitation, the repairs, you have to pay relocation costs, substantial relocation costs of 2 months rent, plus the additional $3,000 if any of them are either 62 or minor or disabled and terminally ill. And there is a very narrow sort of application of this rule where you lived in the unit before, you moved out, you rented it for less than a year, and you did it specifically subject to a lease that allows you to move back in at the end of the year. In that narrow circumstance, you can do it and no relocation payments are required. But that's a very sort of narrow application of this exception. And then kind of the final last big not for cause reason for evicting tenants. State law requires that you be allowed to withdraw your units from the market, that you not be forced to rent them on an ongoing basis if you don't want to. The 2019 ordinance basically contained an exception to allow you to take advantage of that state law requirement. The only real sort of restriction that's authorized by state law isn't that the notice that you have to give is longer than it would normally be in other circumstances. It's 120 days. But otherwise, pretty minimal restrictions. And again, no relocation assistance was required, no payments. The 2002 ordinance really restricts this in every way that it possibly can under state law. So first of all, you can't withdraw under the new 2022 ordinance. You can't withdraw a single unit. You have to withdraw all the units on a given property. So if you have a multi-unit building, you can't just pick one and say, I'm taking it off the market under this exception. The new ordinance also requires a 120-day notice. But if the tenant has lived there at least a year and informs the landlord that they're 62 or that they're disabled, then the notice period is extended up to a year. So you have to give them a year to move out in that circumstance. And if that happens, then you can basically tell everybody else on the property, they can have a year too. So you can, since you're taking the whole thing off, you can keep collecting rent during that time until the year expires and everybody is moved out. Just like with the repairs and just like with the owner move-in, you have to pay the relocation costs, the 2 months rent plus the additional amount for minors and people over 62, disabled, terminally ill. And again, the same limitations on removing an educator or a student during the school year, as we talked about with respect to the owner move-in. In addition to all of those restrictions, there are penalties if you say you're going to withdraw it from the rental market and then you later change your mind or circumstances change or what have you. If you give all the notices, remove people from their units, and then within 2 years you decide, you know what, I'm going to rent these units again, you have to give the former tenants notice if they've asked for it, and allow them to move back in at the former rent. You're also potentially subject to a civil suit by the tenant for up to treble damages, or the town manager can bring a lawsuit to seek damages. If you stay off the market for 2 years, but you're still less than 5 years, again, you have to give the tenant the opportunity to re-enter the unit if they've asked for it. In that case, the new rent is the old rent plus any adjustments that they could have gotten under the rent control law. Within the 2 years, it's just the old rent, period. Between 2 and 5, it's the old rent plus the upward adjustments. But again, you're potentially liable to the tenant for up to 6 months of rent as damages. And then final piece of this, a lot of times people will take units off the market so they can tear the building down and build a new one. That is, you could do that, but if you, after the 5 years, after 4 years, ultimately decide to put the new units back on the market, then normally new construction is exempt from rent control, and we'll talk a little bit more about that. But if you do this, you withdraw and then you build new units and re-rent them within 4 years, they stay under the old rent control system. They're not exempt as new construction. So those are sort of the big pieces of the just cause for eviction ordinance. A few other notes. Obviously a lot of these are very restrictive. We didn't talk about all of the sort of hurdles you have to jump through, all of the notices you have to provide, the text that has to go in those notices, when they get served, etc. But it's a kind of a trap for the unwary tenant. You have to be very careful. You need to make sure that you dot all your I's and cross all your T's, because if you try to evict someone using any of these exceptions and you don't comply with the rules for that exception, then it's potential, the tenant can raise that as a defense to the unlawful detainer and keep the unit. And they can also then sue you for wrongful eviction. And that includes the possibility of, again, treble damages, injunctive relief, money damages, and among other things, one sort of big piece that I will flag is that when you're serving these notices on tenants, whether it's to increase rent, whether it's to evict, et cetera, you need to be providing copies of all of them to the town manager. That's a requirement to be able to follow through on an eviction action. And the tenant can go to court and sue to compel compliance with the ordinance as well, sort of affirmatively, proactively. So that's the just cause for eviction. As I said, it applies to most units in the city. A lot of units, but not quite as few, are also going to be subject to the new rent control rules. So, what units does that apply to? Well, state law basically identifies a certain number of units that are completely categorically exempt from local rent control rules. That includes single-family homes, separately alienable units, which basically is a condo that you can sell individually, or any new unit that is constructed after February 1st, 1995. They cannot be made subject to local rent control rules. So they're exempt from the Fairfax ordinance. Now, some of those may still be subject to state rent control. Basically in Assembly Bill 1482, the legislature applied rent control pretty broadly to units, throughout the state, and said, you cannot raise rent more than either 5% plus the CPI, or 10%, whichever is less. And some of, there are a number of exceptions, but, sort of the takeaway is that there are units that are exempt from the Fairfax ordinance that may be subject to those state rules. And so that the big categories, the most important ones, are units that were built after the February 1st, 1995 date, but more than 15 years ago. So, you built the building, you started renting it in, say, 2001, exempt from the Fairfax ordinance and all of those rent control rules, but subject to that state rent control rule. The other big example, the category here is single-family homes that are owned by a real estate investment trust, corporation, or certain types of limited liability companies. So, if you own your own home, it's still exempt, but, corporate owned units are still subject to rent control at the state level, not at the local level. Beyond that, the Fairfax ordinance applies pretty broadly to most rental units. It has a few exceptions, very similar to the ones for the just cause for eviction. Units that are owned, operated, and managed by the government agency, if state and local law exempts them. Units that are on a property, a development that's 100% affordable under state law. Hotels, motels, inns, etc. Again, on its face, does not have an exception for Airbnbs, VRBOs. The group quarters exception, and I should flag here, unlike the 2019 ordinance that the city council or town council adopted, there's no exception for ADUs and junior ADUs here. They are subject to the rent control rules. So how does it all work? Basically, the rents upon the ordinance taking effect were rolled back to whatever rate was in effect for the unit on February 1st, 2022. Or, if the lease didn't start until March or April or whatever, the first day of the lease. And what basically you get is every year going forward, you get what's known as an annual general adjustment. And the town manager is supposed to announce that every year on June 30th, and it takes effect September 1st. And it's supposed to be an amount equal to 60% of the consumer price index increase. It can't be less than 0%, but it cannot be more than 5%. So, obviously the inflation's been high in the last year. The consumer price index probably is going to be over 5% for the year. You still are not going to be able to take more than a 5% increase despite that fact on an annual basis. As automatic adjustment. Now, that said, landlords can apply to the city a petition to get a larger increase if the circumstances justify it, and if it's necessary to allow a sort of a fair return on investment for the landlord. And I should caution you that that term has a very sort of, it's a term of art, and a fair return on investment is not an easy thing to show that you're being denied. It's can be very difficult. Theoretically, a landlord can submit one of these petitions even before the first automatic increase is announced in June and applies in September. But remember what we talked about at the very beginning, that the town council has to basically approve the implementation by the city once all of the contracts are in place, once all of the administrative structure is in place. As we sit here right now, there are still hearing officers to be appointed. There's still a whole bunch of stuff to be done before all of the process could really be in effect. So, while theoretically you can submit these petitions now, as a practical matter, the mechanism isn't really in place for that. I should also mention that landlords can apply for a larger increase than the automatic one. Tenants can apply for a decrease, or at least a smaller increase, if either the services and facilities that are being provided are reduced, if there is substantial deterioration of the unit, not just wear and tear, but like real significant deterioration, or if there's not substantial compliance with housing health and safety codes. The ordinance identifies specific factors for a hearing officer to consider in deciding whether to grant the petition. So either property tax increase or decrease can be a factor. Any unavoidable increases or any decreases, not unavoidable necessarily, in maintenance and operating expenses. You can pass through the cost of planned capital improvements, which is not just routine repairs, but specific capital improvements, if they're necessary to comply with health and safety codes, and if you amortize them over the life of the improvement. We talked again about the tenant can apply for a reduction based on deterioration of the unit or the failure to provide housing services. And you can also apply for any other sort of reason that's necessary to guarantee that fair rate of return, that you're making you're not losing money, basically. The hearing officer can also take into account what the past recent pattern of increases and decreases is, and the overall purposes of the ordinance. And the landlord has to be able to demonstrate compliance with all of the rules of the rent control ordinance to be able to get it. So if the tenant can say, look, no, you've failed to comply with something over here, that can prevent you from getting an additional increase. You still get the automatic one, but you can't get additional one over and above. Just very briefly, mentioned several times, a decrease in housing services can be the basis for a reduction. Housing services defined very broadly in the ordinance, and it basically means any and everything that the tenant is entitled to under the original lease. So, you take away a utility that they had when they moved in, or parking space, or they don't have access to light or hot or cold water or elevator service that they thought they were going to get. Pretty much anything that lessens the benefit to them of the lease that relative to what it was when they moved in is regarded as a housing service, and then can be the result, or can result in a reduction of rent if they petition to the city. The way the process works for these petitions is you file it initially with the city, and who you file it with is still will be specified, probably the town manager's office. And there's a hearing examiner appointed. And they can ask the parties to produce any sort of paperwork, documentation, et cetera, to back up their claims. And then they make a decision. Are you entitled to an increase, or is the tenant entitled to a decrease, et cetera. Whoever loses can then appeal to the town council as an appeals board. And following the decision by the town council, whoever is unhappy with that can then go seek review in the Marin County Superior Court. I will note that type of court review, that type of judicial review, is very, very, very deferential to the decision of the hearing examiner and the town council. And it's basically if they had any sort of rational reason for their decision, it's going to be upheld. A few other important considerations related to the rent control piece of all of this. This is a big one going back to Costa-Hawkins. Costa-Hawkins adopted for basically all rental units what's known as vacancy decontrol, which means that when a tenant leaves the unit, either they're legitimately evicted under the just cause ordinance, or they leave voluntarily. They move out, they move somewhere else, etc. Whenever there's a vacancy, the landlord has the absolute right to, with a few sort of narrow exceptions, to set whatever rent they want for the new tenant who's coming in. So, as long as somebody's willing to pay it, you can charge it. You are not subject to the rent control limits with respect to that new tenant. But once that new initial rent is set and they've accepted it and agreed to it, then the rent limits kick in and the limit on annual increases after that. One flag for you, just sort of a potential pitfall here. The ordinance says that it's the rate that is actually paid by the tenant that is granted, or that is subject to the limits going forward. And so if you say give the first month's rent for free, that was a big issue in some places during the pandemic, for example, to encourage tenants to move in. You give them that first month's rent free. A lot of cities that have these rules in place will say, look, what you paid for that first year was really 11/12 of what the sort of baseline rent in the lease was, and so that's your amount that you're allowed to increase. It's not the single month number. So you need to be careful about that as a possibility. Any notices that you serve here, again, increasing rent, changing the terms of a tenancy, terminating the tenancy, etc., you have to submit it to the town manager before you serve it on the tenant. And if you don't do it, it's again a defense to an unlawful detainer rule. There's also going to be a new rental housing fee to pay for the cost of all these hearing examiners, etc., in addition to the business license tax that the city already imposes. The amount of that rental housing fee has not yet been set. The town council is supposed to do it. Again, if you don't pay pay the rental housing fee, that is also a defense to an unlawful detainer. Question why the tenant should get to take advantage of that when it's really owed to the city, but that's the rule. And then a final important note, you can no longer charge tenants for utilities unless you separately and individually meter it. So they have their own meter and it's registered directly to the tenant, not to you. And then, there's another potential pitfall here, right? I mean, a lot of times utilities, for failure to pay can place a lien on your property. So there's good reason for you to do it and to pay it to make sure it's paid and you don't have that lien on your property. But if you do that, then you cannot pass that utility payment on through to the tenant. Very briefly, the remedies for the rent control law. If you overcharge rent and the tenant can take you to court and ask for a refund, and they get attorney's fees and costs if they win. And if they show that you've done it sort of purposely, willfully, then they can get 3 times what you overcharge, not just the amount itself. Alternatively, the tenant can file an administrative complaint with the town and get a refund and also costs and damages, but at least in that circumstance, it's limited to $500. Or the town manager can pursue remedies on behalf of the tenants if they don't do it themselves. So, I'm sure for a lot of you that's kind of like taking a drink from a fire hose. I was supposed to talk for half an hour, and I feel like I've already talked for most of the hour that I was supposed to be here. But I'll pass it back over to Michael.
Yeah, well, thank you, Chris, for doing that. I mean, one of the impressions I have is it's amazingly scary when you list the actual potential liabilities for a landlord. There are a couple of gasps in this group because it's to find out the severity of the potential lawsuits that you might be exposed to with these ordinances. It's really kind of it's scaring me. I do have just two quick kind of scenarios and a question. Two quick scenarios that I think are some of the most, in my mind, most egregious. And those go to if you are thinking about selling your house and you have a tenant in there and you say, okay, I'm going to give this person a year's notice because they work for a school district or over 62, you have to give them a year's notice. And at that end of the year, they say, you know what, I like living here. I want to stay. I mean, what are some of the things that can happen? Because you want to sell your house, they don't want to leave. What's a potential scenario like that?
Well, I mean, it's going to depend on how what kind of a notice you gave, right? If you could, in that scenario, if you're planning ahead, you could take advantage of that Ellis Act provision and say, I'm taking this thing off the market. And in that circumstance, that's fine. You can do that. And then if they refuse, you can actually go to court and have them removed. But all of those restrictions about what happens if you re-rent it within the next 2 or 5 years, that's going to apply to the new buyer, right? Assuming that there's some requirements that the town and that have to be met for that to happen. But in most cases, it will. And that may, depending on the circumstances, discourage a potential buyer. I mean, if they just want it for their own, to live in, that's fine. Then maybe it doesn't matter. But if they're thinking, hey, I'm going to buy this and I might rent it, that's not going to work, right? And so maybe in that circumstance, it's worth it to just let the current tenant stay and let them continue to deal with it.
Right. In other words, regardless of your desire, the current tenant, it might be easier from a revenue standpoint to just let the current tenant be in there, in which case then you have to notify the new potential owner. They might not like that. I mean, might think about bringing their mother in or a relative in, and the kind of scenario like that is the potential buyout. It's make me an offer I can't refuse from the tenant side of things, which is a potential liability for the homeowner to pay whatever the tenant wants to move. It's more like a bribe. That scares me.
Yeah. San Francisco, we do a lot of work in San Francisco. Some of the buyout payments are, you'd be staggered. They are, sometimes the low 6 figures.
Yeah. I mean, I don't have that in my retirement. I know a lot of people don't have that type of cash in their retirement. Yeah. It can be a tremendous liability, can it not?
That's right.
Well, the other scenario, let's say you have a mother that is old and you want to move them in there, right? And so they move in. You go legally. You're able to remove your tenant to bring a family member in. Yep. Your mother, she might be 95 years old. She passes away in 2 years. What's that scenario? You can't just say, hey, I'm just going to now rent the space. Is that correct?
If she's been there 2 years, then yes, you can. You have to give, if they've requested it, you have to give the old tenant an opportunity to come back.
Well, you mean, in other words, you're required to address that old tenant, offer them that unit at the price from 2 years previous, or you're subject to triple damages. Is that correct?
Well, in the circumstance you're describing, because it's been more than a year, you have to offer it at the old rate plus adjustments. You get the annual increases, right. and more limited damages in that circumstance. Where you potentially run into trouble is if you're less than a year. Although if your mother passed away, that's not really your fault. Right. But yeah, then so for them to get that opportunity to move back in as part of the original eviction, they have to request that. They have to say, if this unit becomes vacant again, I want you to let me know so I can move in. If they don't do that, then you have more leeway.
The other question is just your perspective on rent control and its kind of resulting effects in the community and how it how it can change the rental supply. There are anecdotal evidence that some people are afraid of these liabilities and maybe won't rent out a space if they're not really, if they don't really need that type of money. Is that a scenario that you found?
Yeah, it's funny you say that because about a year ago, the tax collector in San Francisco put out a report on vacant units in San Francisco, and they discovered, or estimated, I should say, that approximately 10% of the rental units in San Francisco were vacant. And they specifically called out, they said, look, probably not all of them, but a lot of people have said that a reason that they're not renting these units, the reason they're vacant is they don't want to deal with rent control. They don't want to deal with the just cause rules. So it's not only sort of hypothetically, theoretically possible, it's actually something that is known to have happened. And
Right.
so it can be counterproductive. You could actually end up with fewer rental units as a result of these rules, if people feel that they're just too burdensome to comply with.
So we'll have one question. If you could just do this briefly and
Yeah.
Chris, Michael McIntosh, two questions for you. One, okay, I said two questions for you. The first one is for our base rent. How does this apply to the term of art banking? So for rent raises that have not been provided in the past outside of rent control environments such as Fairfax, can we bring that in to increase our bases? One, and two, by providing a full disclosure of these two ordinances, if a tenant is willing to sign a 1542 part of our California government code, will that also allow them to waive their rights so we can actually implement no subletting?
and that's
Thank you.
And simplify that if you can for people who aren't.
Yeah. So I'll start with the second one first because it's a little simpler. There is well, maybe it's a little simpler, lawyer talk. There is a provision of state law that generally allows people to waive their rights in an agreement, settlement agreement. And as long as you do it knowingly, as long as you have the right sort of language, et cetera, these ordinances provide that their restrictions are not subject to waiver. So the short answer to your question is no, you cannot do that here. If the these rules apply regardless, even if you build those provisions in. The first question related to banking, and I think I understood what you're asking. A lot of rent control jurisdictions, San Francisco, for example, specifically allow that if you in any given year decide I'm not going to take the full increase that I'm entitled to, right? I could raise rent 3%, but I'm going to be a nice guy. I'm going to only raise it 2% this year. That you can hold that extra amount that you didn't raise it, and you can imply it in the future. That you don't just lose it altogether. There is no provision in this ordinance for banking, like San Francisco has. So it may, and we'll see how it gets implemented by the town. There's still the town manager is supposed to adopt rules and regulations. But it may very well turn out to be a use it or lose it sort of scenario, which again can be counterproductive. For example, during the pandemic, there were a lot of landlords, who gave concessions to their tenants to kind of make it easy because they knew things were hard. You do that now, and you're giving that concession every year and for the rest of the tenancy.
Yeah, my name is Mike Garanghelli, former council member for 8 years in Fairfax, former mayor. So when we used to do things, we didn't do them in the middle of the night type of situation during a pandemic when nobody knew what was happening. The question really is for me, no matter all the night, by the way, appreciate the telling us about the nightmare that we're looking at. The real question, I think, is how in the hell do you stop it? What are we going to do to stop it in its tracks? There's no one here that wants it to go forward. So how do we stop it? What's the strategy for that?
Thanks for the question. I don't know if you can or should answer that, but that's perfectly fine, Chris.
I don't think I should share privileged communications, but
that's okay.
I share your concern. I understand. Yeah.
Well, then I'm no problem. That's great. I'm gonna have you take off your screen share, and I'm gonna thank you very, very much for all your time and all your effort here. It was a lot of information. we definitely appreciate your insight and answering all those questions and being very, very thorough. We have another guest here. And again, thank you, Chris, and I'll let you go at this time, but thank you very,
My
very
pleasure.
much.
Nice to meet you all.
Right now, we have Blaine Morris on the call. Blaine is a local realtor with a lot of experience in doing transactions in Fairfax and the surrounding communities. And Blaine, you just heard all of the things that Chris was saying. And, if you could hear the subtle concerns behind me right now in terms of how much liability owners have for these playing by the rules, playing strictly by the rules, and what are the effects when they make an innocent mistake, how they can raise the rent. But from your perspective and your perspective on the real estate market and your perspective for the liabilities for buyers and sellers, what's your perspective on all of this?
Bad. That's my perspective. I can't really summarize it any more cleverly than that. But I don't know if Michael, if you want me to start with what I was going to talk about, or if you have any more questions for me.
Please go ahead and please
Okay.
go ahead.
Well, thank you very much, Michael, for asking me to help out here, and thanks everybody for sitting through that great presentation by Chris. That was, well, I would say not a great presentation. It was a horrible presentation, but great information to keep everybody on the straight and narrow. So, I'm Blaine Morris. I live on Cascade Drive. I've lived in Fairfax for nearly 30 years, and I've been a Fairfax realtor for 20 years. And, the question that was asked of me and why they asked me to participate tonight was, what is the effect that this is going to have on Fairfax real estate values? I don't think it's a big hurdle to think that this is going to not have a positive effect on values across our community. The value of your property is first determined by supply and demand. This is true for residential income properties, commercial properties. How many parties are looking to buy property in Fairfax right now, and how many relevant Fairfax properties are available? So overall, in a nutshell, the supply and demand dynamics in any market inform the value of that property. So with Fairfax real estate under rent control, the value of your property will be informed and ultimately defined by how many people might want to buy it. There's 5 broad categories of property that are going to be affected by the Fairfax rent control policies. Number 1, big 5+ multi-unit apartment buildings. Number 2, residential 2 to 4 unit buildings like duplexes, triplexes, fourplexes. Number 3, single family homes with an additional rental unit, whether conforming or non-conforming, and whether the unit is attached or detached. Number 4, single family homes with no unit. And finally, number 5, condos and townhomes. So let's look at each category. Number 1, big 5+ multi-unit apartment buildings. There's no doubt that this ordinance is going to have an effect on the value of those buildings. I don't pretend to be an expert in this category. I've never sold a big apartment building. It's a specialized market. But that says this category of building is definitely going to be affected by rent control and the just cause eviction ordinances. The value of a big building like this is largely driven by the rental income and expenses to support the building. And if the rents are held down by rent control over time, the value of the building as a function of the rental income is going to be affected. In addition, it is very likely that when such a building comes on the market for sale, the buyer pool will be shrunk by the absence of buyers who simply don't want to invest in a market that's rent controlled with rigid just cause eviction policies. It's a common refrain I hear from investors leaving San Francisco or Berkeley: I just want to get away from the rent control ordinances. If they're informed that Fairfax is a rent controlled market, they may well look for other opportunities in neighboring communities that aren't rent controlled. There's a lot of expenses, additional expenses required for rent control buildings, including legal fees and tenant buyouts, all the stuff we talked about earlier in tonight's presentation. Net, fewer buyers equals less demand equals lower value. And this is all going to be anecdotal. We don't know how this is going to play out, but it's not a big hurdle to think that there's just going to be fewer people seeking this type of building. The second category is residential 2 to 4 buildings, duplexes, triplexes, and fourplexes. And these smaller investment properties are going to be affected by both rent control and just cause as well. I'm very familiar with this category. I've sold duplexes and triplexes throughout Ross Valley and down to Corte Madera and in the Valley. The same financial metrics apply to residential 2 to 4 as they do to larger buildings. But the owners and buyers of these buildings tend to be smaller mom and pop investors, probably like many people in the room tonight. We're using these investments to generate income or retirement savings. Oftentimes they live in the buildings themselves. The supply and demand dynamics are similar. And this is where I've come most into contact with these investor rent control expats, if you will, who are taking their investment money out of San Francisco or Berkeley and looking to reinvest in the non-rent control market. If anything, these investors are even more sensitive to the dynamics of rent control, as they don't want to have lawyers on the payroll. The cost of eviction can be devastating for people in this type of property, and they tend to run very tight margins. Very often sellers in this category, especially in Fairfax, in my experience, have under market rent. We have a lot of very cool landlords that Fairfax have kept rents below market for a long time. And so they're often dealing with something of a discount anyway, coming out of the gate on the value of their building, because they often have under market rental income. Since rent control has come into play in Fairfax, I've had one investor tell me they wish they had not invested in Fairfax. If they knew rent control was coming, they would have never invested in Fairfax, and they are now not interested in investing in Fairfax anymore. It's hard to imagine that. It's not hard to imagine many of these buyers taking their investment funds with their market and avoiding Fairfax. So just like with 5+ unit buildings, fewer buyers equals less demand equals less value. So moving on to single family homes with a rental unit. This has been a popular category in Fairfax, especially recently. And by definition, these are owner occupied properties, as the town and banks will often mandate that the owner live in the unit. These properties are generally not purchased by professional landlords. They're purchased by buyers who like the idea of extra income or for a place to house extended family. These are not sophisticated investors, and they certainly don't have a tenant landlord attorney on the payroll. I think it's important to mention that once the Fairfax rent control ordinance are vetted and sussed out, there will become a new standalone disclosure document that will accompany any residential property transaction in Fairfax. It'll be called the, quote, Fairfax rent control and just cause eviction disclosure, or something like that. This will probably be a multi-page document that summarizes the ordinance, directs potential buyers to the town's rent control website, and will strongly advise any buyer who seek the counsel of a qualified California real estate attorney who specializes in tenant landlord law to advise the potential risks of owning property with such provisions. Just imagine getting this document, discussing it with your realtor, family, loved ones, an attorney. Should I buy this rental property in Fairfax? Many of these buyers are first-time homeowners, don't have the means nor the stomach to administer the rental business with such restrictions. It's not hard to believe that some number of these buyers looking for a property, the rental unit, will simply turn their back on Fairfax and go buy a property in San Rafael or San Selmo or the Valley. This means less buyers for any given property. Fewer buyers equals less demand equals less value. So now, single family homes with no rental unit. You might be thinking to yourself, I own my home, I don't rent it. How does this affect me? And it probably won't until you either rent the property when the just cause eviction ordinance will become into effect on your property, but it also might affect you when you go to sell the house. First of all, remember your realtor will be handing all of the potential buyers the same standalone disclosure I just discussed. And again, there people buying single family homes are in 3 categories: people who want a single family home to live in as a primary residence, investors looking to buy a home and utilize it as a rental property, and then people who want to live in the house but want to take advantage of the new favorable accessory dwelling unit laws to either carve out a unit in the main building, maybe downstairs or upstairs, or build an attached unit in the yard. This is a huge category of buyers the last few years. It's always a conversation, particularly if you got a nice size lot or an unimproved downstairs or something like that. They might not plan to do it immediately, but they want to know that down the line, if they want to do that, they can take advantage of that entitlement and build that unit. And that's a big part in Fairfax of our plan to get more rental housing. That's been and that has been working. The town has been quite enthusiastic about encouraging that type of improvements to your property. But buyers in all three of these categories will give the rent control and just cause eviction ordinances some consideration. There will be the same investors, excuse me, that want no part, excuse me, that want no part of rent control and just cause eviction ordinances. There will be those that want the flexibility to build a unit for income, who now have concerns about investing what is a lot of money into a market with serious restrictions on their property that other neighboring communities don't have. There will be buyers that choose to invest in other communities. Fewer buyers equals less demand, equals less value. Finally, condominiums and townhomes, this final category, will not be affected by rent control, but will be affected by the just cause eviction ordinance. And there are investor buyers in this category as well. Frankly, the first investment property many investors purchase is a condo. These buyers will be presented with the rent control and just cause eviction disclosure. And there will be some that choose to invest their money in other communities. Fewer buyers equals less demand, equals less value. Sorry, I keep saying that. But now finally, I'm sure you're wondering, how much will this affect the value of my home? That's hard to quantify. There is a study that Stanford professor did, and I don't profess to be an economist or anything, but they looked at, and this is anecdotal at best, but they looked at Cambridge, Massachusetts, which had rent control from 1994 to 2004. And when rent control was repealed after 2004, the decontrolled market values increased by 45%. And it didn't just affect the rent controlled properties. If you were in the 75th percentile of being near rent controlled properties, your property gained 13% more than properties that were in the 25th percentile of exposure, meaning the closer you are to a big chunk of rent controlled properties, the more effect it might have on the value of your property. So again, I don't necessarily think that that's a real apples to apples comparison, but I do think that it might be, tangerine and oranges. They're kind of similar. In a hot market, there are often multiple offers parties competing for a property. We just came out of such a market. In a market like that, it could be a matter of less buyers for your property because of all these things, and ultimately less value. In a soft market, it might be you only have one buyer, or the property sits on the market for a while and you wait for the right buyer. There could be less buyers for Fairfax properties. And again, fewer buyers equals less demand, equals less value. I already have income properties. I talked about that earlier, the income property buyers that are kind of taking a step back from Fairfax. The supply and demand dynamic could affect the value of your Fairfax property, obviously. Let me discuss one last provision. And we talked about that earlier with Chris. And I'm putting it into the category of, I don't know, it's never happened before. This is the provision that if you displace a tenant and move out of your building, if you displace a tenant to move into your building, if you choose to rent that unit in the future, you need to offer the unit, the tenant, and they went through all of the nuances of that, but it goes out to 5 years. At the same rent as before, plus some minor increase. As far as I know, I've asked a number of people about this. This is the first time this type of provision has been adopted. I don't know where that gets memorialized. I don't know if it's with an attachment to the title at the county, with something specific about John and Jane Doe tenant and their rent. I don't know what the bank's going to think about such a thing on that, with some sort of entitlement to the property for some third party. I don't know. This has never happened before. And think about Bill and Betsy Buyer buying your house to live in themselves. They'll need to know about this entitlement. And Chris talked about that earlier. They'll need to know about the terms of the entitlements of John and Jane Tennant. What if John and Jane Tennant had below market rent before you bought the house? What if Bill and Betsy Buyer get a job transfer, or they got to go to LA to take care of their sick mother? And they need to rent their place out. And under that circumstance, what if their new mortgage is way more than the below market rent is going to cover for that? You got to rent them anyway. Do you think it's possible in this kind of scenario that Bill and Betsy Buyer might take some pause in buying such a house? They might well go look at some other less complicated house to buy. So one last time, fewer buyers equals less demand, equals less value for your home. Michael, that's as much as I can offer tonight, and God help us all.
Yeah, exactly. I think you got a lot of people who are very enlightened tonight, but also feel very scared. My one of the things we all love this town. I mean, that's why we live here. I came out here after about 20 years of renting in San Francisco, Sausalito. I came out here. My path to home ownership was that I needed to buy a place that had a rental unit on there. I mean, I was a single guy. I knew I couldn't afford the entire mortgage. I had to buy a place that had the rental component. For me, it was a pathway to home ownership. It was the only way I could get to be able to buy a place. I know, with the mortgage rates going on now and, just craziness, the unaffordability of anything, whether it's renting or purchasing, people are looking for different ways of getting into the housing market. And one of the ways is to purchase a place with a potential rental unit or an ADU or a duplex or something like that. And my concern is that because of the potential liability and the onerous nature of these measures, it's just going to scare so many people and so many potential first-time home buyers, people, young families, people want to move their young kid in here. And that's what really scares me, is it's going to change the character of Fairfax. We're no longer going to be that is no longer going to be an option for home ownership for a lot of people. And that's kind of where I kind of, it's not me, but it's other people that are going to be affected by this. And I don't know if you have people who have looked with you for houses like that, specifically for that. What's your experience with that?
You mean since this ordinance came into effect?
Well, even previous to the ordinance, in comparison to
the scenario, Michael, the scenario that you described is very common, where there's an income potential on the property. You can leverage a larger asset. It helps obviously cover your monthly mortgage. And again, I don't think these things are going to go away. And in spite of all the doom and gloom tonight, I think that there's still going to be a market for our Fairfax properties. And don't get me wrong, Fairfax is still a wonderful place to live, and highly desirable. But I do think that again, this, when you hand a buyer a standalone disclosure of all the things to look out for in Fairfax rental market, it's going to give people pause. When you think about yourself, when you moved out here to buy the house, you were a sophisticated professional landlord at that time. It was all very daunting. I think about when I bought my house, it was, I couldn't believe anybody was going to loan me that much money. And if you lump on top of it a need to consult with an attorney, and again, I think in our attorney friends, they'll default to what's the worst that could happen. That's all you're going to hear. And so I think we're going to have to see how it affects the market. And hopefully, I know that I did see at least one member of our town council on this call tonight. And I hope there's more. I hope that perhaps they realize what they've done. I mean, it seems like it was an ordinance that, like in Washington, when they are going to try and put some new law out, they put the most egregious, one-sided, horrible law out there, expecting there's going to be some negotiation back towards the center. That never happened here.
Recall.
Yeah, we have some pitchforks and torches coming out here. And that's the one thing. And one of the things I just also want to reiterate, and you were mentioning a lot in terms of supply and demand. And one thing we just haven't talked about, just touch on really briefly, is the supply and demand of rental units. I know anecdotally that there are a couple of people, my neighbors in Fairfax, that have said, you know what, I'm retired. I might not need the income. I don't want the hassle. I'm not putting this space for rent. I'm just not gonna do it. I don't need it. I'm not gonna do it. And my concern is when you have a same demand, because Fairfax is such a beautiful place to live, and you have fewer rental units, what happens to the rents for people who want to move in here, or the current renters who maybe get, have a boyfriend and girlfriend they're going to move into. They're going to find another place. They're going to be out on the rental market. What's the situation going to be like for them?
I don't think anybody would say that open market rentals in San Francisco, Berkeley, or Santa Monica are offering any great bargains out there. I think that people are incentivized to not move. It creates kind of a strange market where people that are in rent controlled units, who may be getting along in life and are empty nesters and have a rental unit that's big enough for a family, but they have a low rental amount, they're just going to stay. And then that creates situations where you've got, 3 or 4 people, or 7 or 8 with the new subletting requirements on the Fairfax market, filling up smaller units. I mean, there's a woman I've been speaking with for some time about potentially selling her building, and she got rid of there was a difficult eviction last year where the house was, there was some damage. After a period of time, got that unit vacant, and then set on a fairly extensive rehabilitation of that to fix it up, because it was, quite frankly, in pretty bad shape. Rent control passed. In the meantime, she's not going to rent it. She's keeping it vacant and figuring out when the right time to sell the building is. And that's a unit that is going to be very appealing to owner occupant, because it's a large unit. And so someone's going to buy that and keep the tenant downstairs and move into this. And that's going to be a rental unit that's going to come off the market. And I think that's not going to be an isolated situation.
Yeah, I don't think so either. Well, Blaine, I want to thank you for your time. I know we'll have one question here from the audience. If you want to either jump up here or shout it from your seat.
Yeah.
And if you have a chance, just answer a question, Blaine.
Hi, I don't expect you to necessarily be able to answer this, but what I think is really important is to know that this particular council, they pass one set of laws, and then they come back and they keep adding more, and there's nothing to stop them. If we do not recall these people, it is only going to get worse. Thank you.
All right. Thank you. And I guess just because I'm cognizant of time and 7:30 right now, I have 2 appeals. One is for the 150 people or so still watching this, who are homeowners, who are landlords, and also tenants. We encourage you to reach out to the town council, to send them an email. And tomorrow night, there is a town council meeting, like every month. Tomorrow night, I believe it's at 6:30. You can attend either in person, like I am, and like a number of other people.
Yeah, I heard they canceled it.
All right. Well, I'll just say then the next town council meeting, although it's not tomorrow night,
February 1st.
we want February 1st, is what we heard here, is that we would like the homeowners and the landlords and the renters to tell the town council how they feel about these ordinances, how it's going to affect them, their current income, their retirement, and what they can do with their property. And, if they're all great with it, great. But if they have some complaints, if they want to voice their concern, we definitely encourage them to reach out directly to the town council or be at the next town council meeting whenever that's scheduled. The other big concern that I have is that, and going back to the original ordinances, is that the people of Fairfax were not allowed to vote on these ordinances. The people who are vested, the people who have money tied up in their homes, 90% of my net worth is tied up in my home. And when a small group of people, the town council, 5 people, make decisions, substantial decisions that affect my livelihood and my retirement, I get a little concerned, I get a little angry, and I want the opportunity to vote on those measures. So it's for all the remaining town council people who are on this call, we are requiring you to rescind these ordinances and bring them to a vote of the people. So, Michael, just remind me that we are looking forward to another more interactive event where we will be able to take questions, a lot of questions from the audience, and have them answered by experts or maybe town council members. Maybe they'll show up and try to answer some questions for us. But Blaine, I want to thank you for your time, and I want to thank all the all the attendees for their time, and hopefully it was very, very informative. I appreciate you guys checking out fairfaxresidents.org for some of the latest information. I hope to have this video up on that site very shortly. I want to thank you, Blaine, and again, thank you to our tenants and everybody who's remaining here. Thank you guys very much.
Thank you, Michael. Thanks, everybody.